Welcome to the PI Show, viewers. This is a show where we talk about everything relating to personal injury and how it relates to you, the viewers. My name is Nunzio Tartaglia and I'll be tonight's host in place of Tony. With me, I have our resident WorkCover specialist, John Karantzis.
Hi Nunzio, hi viewers.
And we also have a special new guest, Alexandra Agathouli, is also a lawyer.
Good evening, viewers.
Tonight we'll be talking about Comcare, which is effectively a federal WorkCover system, and we'll have different views from both John and Alexandra about this interesting topic.
However, before we get to that, Nunzio, what's in the news?
Well, there's been lots in the news, John, and the first cab off the rank is the sad story of A and Cole, and I'll get to Alexandra to mention the facts of this.
Yes, Nunzio. Tragically, in August 2011, young Ahan Cole was attacked by a dog, and unfortunately she had died. She was killed. It was sad. Her mother was present at the time. Little Ahan was clinging onto her leg. She was attacked by this dog. You know, unfortunately, she had passed away.
And now we've got court proceedings have been issued suing the owner of that dog, Nunzio.
Yeah, look, proceedings have been issued suing the owners, and look, hopefully there's the two issues that I can see out of this, John, is that obviously, first of all, the mother's got to prove that she's got post-traumatic stress disorder, which, look, I think that's going to be apparent to all.
Yeah.
The other issue, which, look, I hope is not an issue in this case, especially for the mother, is insurance. Do you think that these potential defendants will have insurance?
We're not talking about a company, are we?
No.
We're talking about an individual, and if he doesn't have his own, I guess, house and contents insurance, well, there's a problem, isn't there?
Yeah, and that's always the problem when it comes to these dog attack cases. Not all people's insurance policies are attached to incidents of this nature. And look, I really hope this is one that it does equate to it.
At the same time, I guess, if the dog owner has assets in his name, well, there's money there.
Oh, of course. And look, let's hope that's the case if insurance isn't there. But Alex, what potentially can Ayan's mother be suing for? What type of damages are we talking about?
Well, she could be suing for, I guess, general pain and suffering. She was present at the time, so that's important. That you need to be, if you're directly affected as a result of someone being killed.
What's the threshold in order to satisfy the pain and suffering damages?
Well, the mother would need to satisfy the test, which is 10% whole person impairment.
Well, look, we'll stay tuned for that. I'm sure we'll hear more about it.
And I guess it could be a claim for economic loss if the mother was working and stopped as a result of the injury she suffered.
Oh, no doubt. Look, I'd be stunned if she could get back to work after such a just devastating accident.
Yeah, we're glad that the Victorian government has passed those strict laws regarding dogs and those menacing dogs in particular.
I think, obviously after this, there was changes enacted, and the defendants in this case only got a monetary fine, but potentially got jail time if that legislation was in place at the time. So anyway. John, next case, swooping birds.
The swooping
Tell
birds.
me about it.
Yeah, Nunzio, it's a very interesting case. Proceedings have been issued against a local council in Melbourne regarding birds that have been attacking people in a car park. Now, apparently there have been previous complaints about these birds, which the council has not heeded, has ignored, and she's issued court proceedings against the council in regards to these crazy, angry birds.
Alex, exactly how did she suffer the injury? What was the mechanism of the injury?
This lady was at a kindergarten. She was walking through the car park carrying her 3-year-old niece. And what had happened was she saw the bird coming toward her, so she twisted her body to avoid being hurt, and as a result she fell down to the ground and sustained some serious injuries to her back. Yeah,
look, looking at the pleadings, John, it appears that there have been potential alleged complaints at this kindergarten about the danger of these birds, and obviously what it poses to both students and parents and the like. And I think that's what this case will come down to, don't you think?
Yeah. So look, I guess it's a wait to be seen at this stage. We'll see what happens. The outcome.
Look, I think it's polarised a few people reading it, and I'm sure there'll be more to come in this case. Anyway,
there were a lot of questions about is the bird insured, or is the bird individually named in the court proceeding? But no, it's the council that is liable for basically ensuring a safe public place, and in this place they have control
That's right.
of it.
So
yes,
we'll stay tuned for that one, I think.
Exactly.
Okay, Alex, next case is regarding the coroner and the sad case of the gentleman that was found, unfortunately, in pool of his own blood. What exactly happened in this case?
This matter is about a man who was at the Melbourne Psychiatric Hospital, and he basically was found in a pool of his own blood.
And no one knows what happened, but the coroner in this case, Nunzio, was scathing about how the police conducted the examination, how they conducted the investigation of this incident. The coroner was so scathing, Nunzio, I was actually quite surprised at the incompetence shown by the Victoria Police in this case.
Yeah, because just on the facts of it, John, if you look at just what was found at the time, obviously found in the pool of his own blood, I think there was a plastic
Bag.
plastic bag there. Clearly, there's something amiss here, and
Exactly.
and just the fact that evidence has been not properly contained and could have been potentially tampered.
Vital witnesses were not interviewed. Clearly, something has gone awry here, and it just goes to show that all these state organisations, they have a duty of care to all these people that live in their facility now, and they are liable for the safety and well-being of everyone in these institutions.
What was interesting though is that the coroner weren't scathing, or there's no sort of negative remarks about the Austin Hospital with respect to this, but at the same time, the Austin Hospital have changed their policies since the accident. Do you think there potentially could be some liability there?
Oh yes, the procedures have been changed, so I think the they themselves realised, we have to do things better.
Yeah. Alex, does the family potentially have a case against either the Austin Hospital or the police?
Well, yes, they could, similar to the previous matter, that, if you're, directly affected and if you're directly related to the deceased, then you do have potential to make a claim.
Post-traumatic stress.
Post-traumatic
Yeah, and if
stress,
you can prove negligence. So, look, I think more to come on that one too. But look, Bills, it's time for a break. Following the break, we'll be speaking about Comcare, so stay tuned. Welcome back, viewers. It's time now to speak about an interesting area of Comcare. Look, we've concentrated a lot on WorkCover, and I think it's now time we speak about Comcare. And we've got Alex to assist us with that, and we've also got John to make the comparisons with the state WorkCover jurisdiction. But first and foremost, Alex, what is the Comcare system?
The Comcare system is the Federal Work and Health and Safety Regulator. It's a national scheme that's integrated through the Safety Rehabilitation Compensation Act. So basically, examples of federal workplaces are the Australian Public Service, and also companies who are self-insured and have been given the ability to be self-insured under the Comcare scheme. So examples of those companies are like Linfox, Telstra, the Reserve Bank, John Holland, Australia Post.
National Bank. I think there's a lot of banks now that are self-insured.
Yes.
Is that right, John?
Yeah, ANZ, yes.
Yeah. So effectively, John, the way I compare Comcare, it's WorkCover but on a federal context.
It's a federal context, but it's a very mean system, Nunzio. It's a very nasty system compared to the Victorian WorkCover scheme.
I know you've got some views on this, John. So look, tell the viewers, what your concerns are with the current system.
Well, look, weekly payments and medical expenses, a comparison, they're pretty similar, aren't they, Alex?
Yes, they are. The only difference is that weekly payments are up until retirement age, which is 65 at the moment.
Whereas with the Victorian WorkCover scheme, after 130 weeks, you have to show that you have no work capacity for suitable employment.
That's correct. So
that is one advantage of the Comcare scheme. However, it's the common law damages lump sum, that's a big problem. Under Comcare, What is it?
You have two options. You can make a claim for an impairment benefit, and you have to satisfy the test of greater than 10% whole person impairment under the Comcare guides, which is a bit different to WorkCover, which is the AMA guides.
And it's probably just on that, it's probably not as favourable or as easy to succeed upon as, the impairment under the
Most
WorkCover
certainly
system.
not. The Comcare guides are a little bit pretty strict compared to the AMA guides.
And what are the normal payouts there? 10 grand, 20 grand?
10, 20, 30. The maximum you can compensation you can get under an impairment claim is $80,000.
$80,000.
That hasn't
That's the
changed
maximum.
since the 1988, since the law was enacted.
And if you don't elect to go that way, you can go another way.
You can, yes, you can elect to pursue common law damages. It's unfortunate that you can't have both an impairment and a common law settlement. And again, for pain and suffering, it is capped at $110,000. So,
and that's it. No more money.
This legislation was enacted, I think, in
Over
the
10 years ago.
1988.
and it still hasn't been indexed on. It's crazy.
No.
It's stated 110,000. What's the WorkCover?
Well, that's the real issue. Under the Victorian common law jurisdiction, for lump sum claims, for pain and suffering, cap is around $560,000. That's the maximum. Then for economic loss, it's over $1.3 million. And that's for people, that is reserved for people that are severely injured, quadriplegics, tetraplegics that will never work again. But you've got the usual payouts that could be, $300,000 or $400,000 under the Victorian WorkCover system for common law damages claims. Under the Comcare system, you can only get $110,000 maximum. It's ludicrous.
And you can't sue what's worse for your economic loss, John. You can only sue for your non-economic loss. It's
yes.
I still think it's it's the part of the system that needs to be looked at, don't you think?
It's a system that the government is looking at the moment. Unfortunately, the changes proposed are even more draconian, aren't they, Alex?
Yes, that's right. With the new changes, it's going to be a lot harder to sue for common law damages because they're proposing to allow more companies to be self-insured and under the Comcare scheme, which therefore minimises the amount of common law claims that can be made.
So effectively, John, that will impact more your area of WorkCover if more companies are going to be granted licences to be self-insured and to be under the federal scheme. You're going to have, there's twofold effect. One, the premiums will go up for the state system.
Exactly.
And secondly, workers, more importantly, don't have rights to lump sum entitlements.
They don't have rights, but not only that, then you're condemning a worker to a life on weekly payments. Whereas under the Victorian WorkCover scheme, because you can get a payout, a worker can get a payout and then move on with his life and not be stuck on the system getting weekly payments for years on end. And this is where philosophically we say there's a lot more advantages to the worker, but not only to the worker, to the governments themselves. South Australia and New Zealand do not have common law systems. Guess what their economies in regards to the workers' comp scheme is? $100 million in the red. They're negative. They are losing money, New Zealand and South Australian WorkCover scheme, because they don't have common law, whereas the Victorian WorkCover system, it's a very healthy system. They're $100 million in the black.
They're making money.
They're making a profit because people are getting their payouts and then moving on with their life.
Look, and that's why I think these current reforms that have been proposed by the Senate Standing Committee have been polarised the community, because the rights of workers are now, they're worse off. What are some of the other changes? The interesting one that I found, Alex, was the authorised recess proposed.
Yeah,
change.
that's correct. So at the moment, if you are away on secondment or you're being sent away,
or you're on your lunch break,
or even on your lunch break,
yeah.
Yes, that's right, and you're injured, you can claim compensation. However, with one of the recommendations at the moment that you can't, I guess, be compensated if you are injured during an authorised recess.
So effectively, John will be able to confirm this. But if I go to Woolworths during my lunch break to grab some items there, and I have a slip and fall on a grape, I can put a WorkCover claim in.
Exactly.
But under these new changes, no claim.
That's very odd. I mean, Yeah, that's very odd, Nunzio.
Yeah, so look, it seems like that, eventually there's going to be no rights available to these workers, and that's why I think it really needs to be looked at a bit more closely.
And it's not as if payouts are really massive and big, and there's a pressure on to limit the payouts. The payouts in Comcare are very minuscule.
Yeah, and because of the type of people who have licences or are self-insured, they're more white-collar workers as well, wouldn't you say?
Exactly, yes. Yeah. Yes, office workers.
One other thing else before we go to the break though, if you aren't suing your employer but there's a third party involved, what's the process to sue?
So it's basically very similar to a public liability matter. So for example, if you're injured whilst working but you're off-site and there was something on the ground and you slipped on that, then you could potentially sue the negligent third party for the injuries
and
that
then
were sustained.
it's the same public
So it's the
liability
same
thresholds,
process.
over 5% or 10%, whatever it is.
That's correct, yes.
Okay. Well, look, guys, it's a really interesting topic, and after we come back, we've got two very, very interesting cases which we think you'll enjoy. Stay tuned. Welcome back, viewers. Before the break, we were speaking about the Comcare system and its general mechanics. So now we're going to speak about a couple of interesting cases. And the first one, we've spoken about it briefly in a previous episode, but I think it's time we give it a bit more detail. And it's that of Comcare v PVYW. Now, there's no person named PVYW, but Alex will tell us why this person's name was kept confidential.
I guess this person wanted to be kept her name away from the media, I guess. PVYW was an employee of the Human Relations section of a Commonwealth government agency, and she was required to travel for her work duties. During a work-related trip in a regional town in New South Wales, she was staying at a motel which was paid for and arranged for her to stay by her employer.
Yep.
Whilst at the motel, she had engaged in sexual activity with a male acquaintance. And during that time, a glass fitting from above the bed was pulled down and it was pulled from its mount, so it struck her in her nose and her face. And she sustained physical injuries and,
She put a claim in.
put in a claim in basically.
John,
Yeah.
What was
set of facts.
What was the basis of the claim that this was in the course of work and therefore she should be compensated? The sexual activity.
The reason why she put in a claim is because she was away from her usual workplace, and the law allows for, if you're away and it's arranged by your employer, they're paying for it, then you're entitled to compensation because you're away from your normal workplace.
Various courts found various different decisions, didn't they, Alex?
That's correct. First instance, this was heard at the Administrative Appeals Tribunal, where the senior member had made a decision that she would not be compensated for her injuries because it was not something that the employer could have foreseen that she'd be engaging in that particular activity. It was appealed to the federal court. The federal court decided that she would be compensated.
Why is that though?
Because they said, it was relating back to the fact that she was away for work and that, she'd be expected to be engaging any form of activity, and it didn't specify as to what sort of activity she would be engaged in if that was sustaining an injury.
They referred to a case in that judgment, which is Hatzianolis.
Hatzianolis, yes.
Where effectively that particular employee was away for work, but then his employer arranged a sightseeing tour, which where he sustained injury, and that was regarded as also in the course of new employment.
That's correct.
Yeah.
So we've got a situation whereby if the employer had paid for that actual activity, then maybe you would be covered under WorkCover laws.
I
under
guess.
Comcare WorkCover laws.
Well, that's correct. Well, that's what I guess that was what it came down to at the end, because again it went to the full court of the federal court, and they pretty much said that no, she wouldn't be compensated. That she was to be compensated, but
yes.
the High Court
That was
decided.
appealed, and that was appealed by the employer.
Yes.
And there was a lot of media coverage at the time, wasn't there, about the full court decisions, literally saying someone having sex on a work trip is covered by Comcare WorkCover laws.
Yes.
There was a lot of media coverage. Now, that was appealed by the employer to the High Court.
Yes.
What happened there?
Well, it was a 4-2 majority where the High Court basically said, yes, they understand that she was away for work and that she was engaged in a particular activity, but it wasn't an activity that her employer could have foreseen that she would be engaged in, and therefore, she was found that it wasn't something that she could be compensated
There
for.
was insufficient connection with her work duties.
Correct.
For there to be coverage by Comcare.
I think the question that the High Court wanted answers was the correct question was that did the employee induce or encourage the employee to engage in an activity, or induce or encourage the employee to be in that place? Now, in terms of that activity, it didn't seem like the employees induced
No,
her
it's
to,
not part of your work requirements.
No, but John, okay, what about her going to the gym? You know, she got back from work that day, decides to go to the gym.
Well, look, that's interesting because most likely the employer would have paid for that. But at the same time, is there sufficient connection to your work?
All right, give us the...
That's the question.
WorkCover VWA, do you think this claim would have been accepted?
Again, most likely no.
Okay.
No,
So,
again, because of the connection and the lack of connection to your work duties, your work activities. At the same time, in Hatzimanolis, the employer has paid for the worker to go on an actual sightseeing tour and is injured on that actual tour. So there you can see on those circumstances, yes, you will be covered. But in these circumstances of private sexual activity, it's just not... WorkCover laws aren't there to cover that.
do you think it's gone too far?
Exactly.
I guess though, if she was away for a longer period of time, so the fact that she was only away for a short period of time, in a few days, then it could be, it's not foreseen. However, if she was away for a longer period of time, and again, if she'd slipped in the shower or something like that, she could have, the facts are different. So if it's an extended period of time...
How does the shower differ?
Oh, look, I have to admit, if she slipped in the shower, I'd probably say she would be covered.
Why is that though?
That's something where that's a normal expectation that someone be having during your business, during a business trip, having a shower in the morning.
Look, it's a very peculiar set of facts.
Exactly.
I can understand, I suppose the avenue which the High Court went, but at the same time, to me, the trend is that it's becoming harder and harder for any person on Comcare to have an accepted claim, John.
And in WorkCover generally.
Yeah.
But it always comes down to the facts in question. But in these type of circumstances, look, we have to agree with the High Court.
Just before we wrap up, though, Alex, do you want to quickly give the viewers the facts of our last case, which is Kostetsky and Comcare?
Yes, this was about an employee, Mrs. K. She was employed by Centrelink, and she was subjected to bullying and harassment by a manager. Her manager would stand over her desk and constantly belittle her and humiliate her during team meetings. And then she was then, went off on maternity leave, came back, and then she went to a different position and in a different sort of area. Yeah. She was comfortable there. The manager that was there said that, we'd be happy to have you here, but there was no longer a position available, so she had to go back to the old location and because of the fact that she was being subjected to bullying and harassment during the first time, her employer knew and was aware that she was, she had some form of, psychiatric effect as a result of the bullying and harassment. And therefore, the question is whether it was reasonable administrative action, because in the defence, Comcare said that, reasonable administrative action was in relation to the fact that they had changed her position and that she had a reaction to that particular
So, Alex,
action.
the key here is basically the employer literally forcing her to go back to a situation where the employer were on notice and knew that she felt threatened and bullied and belittled.
That's correct.
And the outcome, Nunzio?
Yeah, John, the applicant succeeded in this case, and it was basically regarded or determined that what the employer did was not reasonable administrative action. So, look, that's all we have time for tonight, guys. We could have went for a lot longer time, but I'm sure we'll come back to it in other episodes. I just want to thank John Karantzis and also Alex for tonight. Any final words, John?
Nunzio, Comcare, it's a very difficult and complex system. Alex is our expert in regards to Comcare. Please, viewers, give Alex at Nwiki Carbone a ring. She's expert on this area and she'll be able to assist.
Thanks, Alex, for coming on. I'm sure we'll get you back on soon.
Thanks, Nunzio.
Viewers, thanks for your time tonight. Please give us any feedback on Twitter, Facebook, and please look at past episodes on YouTube. And until next time, stay safe.